Hi, my name is Thompson.
And I'm Pei Yi.
And we are from Singapore.
Okay, we took the University of London LLB program. I have benefited a lot from this. I've come from a banking background with no knowledge on law, but I have learned a lot from the judges' decision making, and I think it is really beneficial in my managing work in the bank.
Well, having a law degree doesn't mean that you have to become a barrister. Well, it also helps in your everyday life and also, in your job, whichever vocations you are in.
Hi, my name is Mohammad Riyasuddin. I'm from Singapore. I graduated from University of London with Bachelor of Laws in year 2011. I was working with the Singapore Police Force and I developed this interest in law. So University of London provided me with an opportunity to read law as a part-time student, which other universities did not provide. So that was the reason why I chose University of London. I'll recommend the program to anybody who is serious about acquiring knowledge because the University of London program is tough, as I told you, but nevertheless it's useful, it is valuable because you could apply it to your work as well as your personal life. So yeah, I'll recommend it to anybody who's serious about knowledge.
Hi, my name is Jay Walia and I studied for the Bachelor of Laws in University of London. I graduated in year 2012 and I am a singer, songwriter, actor and a TV host. My passion has always been music, and since the age of 17 I told myself that I was going to make music my career. Entertainment was going to be my home. But I also wanted to have something extra. And my parents wanted me to have something extra as well. So, we opted for a law degree at University of London. And the reason for that was, number one, who doesn't know London? Number two, the syllabus was pretty flexible. I was able to do music at the same time. I was able to focus on my law studies and it worked out well. Making music my career and having a law degree, you will wonder is he just wasting his degree away? But I'm not. I am my own manager. And most of the time, that means I'm also my own lawyer. I apply it in my daily lives, in my contract negotiations and all that. And there are a lot of contract negotiations, so it worked well. I apply it quite often. Reactions from people, especially in what I do, from the entertainment side of things. When they meet me, they assume that I studied music or I went to theatre school or something like that. And then when I tell them that I have a law degree and a University of London law degree at that, it's a pretty big reaction. Everyone goes like, "Whoa, are you sure you're in the right place?" Or, "Are you sure you are here to act?" The legal department's upstairs, stuff like that. But yeah, it gets a big reaction and I think it helps break the ice as well.
Hi, I'm Denise Aiken and I am from Jamaica. I studied the University of London LLB program. I specifically chose the University of London because it allowed me to study intellectual property, which is an area that I am particularly interested in. And I found that a lot of the other universities did not offer that course, or to the extent that University of London offered it. I'm currently a Group Insurance Administrator at Sagicor. I graduated from the University of London LLB program in 2010, and I am still ecstatic about it.
My name is Naseem Jalili and I've just recently completed the LLB program. I very much enjoyed the program. I've been doing the program sort of full-time while working full-time and having my family as well. So it's allowed me the flexibility to do both. My biggest tip with trying to keep up with this program is having a daily schedule to follow. I think it's very overwhelming if you are trying to imagine what you need to get accomplished for the whole year, but if you have daily tasks, it's very manageable. The best thing about studying with the University of London was it is a world-renowned university, but it allowed me the flexibility and the room to study on my own pace. I would highly recommend other students to consider University of London. I have actually encouraged my husband to take on the same program, so he's already registered with the LLB. He should be doing his exams shortly. I'm very excited and very privileged to have this opportunity to come here, and I've been imagining this day for a long time, so I'm very excited to be here today.
Hello, hi. Very good morning to all of you, and welcome to our BAC online preview. Thank you for joining us here on Facebook Live as well as on Zoom. And for our Zoom attendees, thank you for muting your microphones. And I want all of you to stay to the end of this session because there are two great things happening at 11:30 or thereabouts, where we want to open up a time of Q&A and to be able to answer your queries. And at the same time, myself and my colleagues, we will give you a trial lecture on what studying law is about, right? So my name is David, and thank you for joining us this morning. And I hope that for this morning, at the end of this session, that there will at least be two things that we will be able to assist you in your query. And that would be number one, why do a law degree? And of course, number two, then why do law at BAC, right? And who is BAC College Singapore? And starting with the first question, and we get this question all the time, where people ask, what can I do with a law degree? And I think that we are all very practical people. We want to know what is the end game, right? For example, is it possible for me to get a job that pays well? What do I learn in a law degree? And so in this slide, I've captured some of the common responses that our graduates have given us on how or why they embarked on doing a law degree. And you would notice that there are many different reasons as to why people do a law degree. And I am not surprised that even as you are looking at the screen now and all these points, that you would find that at least one or more point may be the reason as to why you are here with us this morning, watching this and to finding out more about a law degree. For some people, it could be a sense of achievement, for self-actualization. They may come from a family or lineage of lawyers. For many others, it's because they want to have a more diverse career path, a different qualification to add on to what they have, or even maybe to become a lawyer. And I'll share more on all these things afterwards. But you'd be surprised that there are actually quite a fair bit of people who join us on a law degree program because they recognize the so-called transformative effect or power of pursuing a law degree. And when I say this transformative effect, I'm referring to how a law degree or the pursuit or study of law is such that it can transform someone's mind. The way you look at problems, the way you present arguments, the way you articulate your point, and the way you have a different paradigm shift in seeing how things can be solved and in coming to a legal solution to practical problems. And so these are soft skills. These are transferable skills that you find it's being used not just by lawyers, but obviously for every professional that seeks to want to be competent and excel in his or her job. You want to be able to have such kinds of soft skills, right? To look at things differently, to solving problems. And so these are just some of the reasons that as to why people do a law degree. Now, however, I must be honest that there is one reason that I did not put down here, and that may be that some of you are watching this and you're saying, well, David, I want to do a law degree because I want to be like Harvey Specter. If you watch Netflix, Harvey Specter is this show from this guy from Suits, right? This great show. I like the show. Very charming guy who is a great lawyer. And maybe that's why that got you motivated to doing a law degree. I don't know. Now, but if you are watching this and you want to emulate, a famous lawyer perhaps, and that's your source of inspiration, do stay till the end of a session and where we have a trial class. And when my colleagues share more to you about a study of law, then you will have a more accurate sense of what law is about and what studying law is about, right? And would you then see how this law degree can bring you closer to achieving your passions and your dreams, right? But to be more specific insofar as some of the careers that one can embark on, of what a law degree can do for you, obviously a law degree in a very traditional sense. People do a law degree to want to practice. And yes, the law degrees that we are offering here at BAC, in particular the one from the University of London, is such that it is a recognized law degree for practice in the UK. It's a UK law degree, right? As well as a majority of Commonwealth countries. And so that's one possible pathway. But I want to be very clear this morning. Many of you watching here with me are from Singapore, and the current position is that the Singapore authorities do not recognize this degree for purpose of practicing as a lawyer. It's recognized as a degree in terms of general work. And I'll share more on that afterwards. But in terms of practice, I want to be very clear that the UK law degree that we're offering here at BAC does not automatically lead you to practice. There are maybe some additional routes that you can take to end up in practice. And I'll share more on that also afterwards. But in this slide, you see how, in terms of legal services, it's not just a practice, is it? So for example, a very common route or career pathway that many of our students choose is to becoming an in-house counsel. And shortly afterwards, I'll show you some slides of some of our graduates who are now successful working in the legal services industry as in-house counsels, as prosecutors. And so there are, in that sense now, other career paths that's possible, even though you may not be practicing as a lawyer in the conventional sense. When I say in-house counsel, just to maybe explain a bit more on that, that would refer to those who are working in the private sector with a company, and they are doing the job of a lawyer, so to speak, for their employer, for their company. Their job is to review contracts, negotiate contracts, draft contracts, ensure that all the regulatory matters and compliance matters are complied with. So essentially, they are putting their law degree to good use as an in-house counsel to ensure that all the legal issues are taken care of by themselves for the company. And that's really one route that a law degree can lead you to as well, even though you may not end up in practice. But assuming now that you want to look at the law degree to open up more doors for you. And I think that some of you here right now watching, it may be that you are already in a current profession. Perhaps you are an engineer. Maybe you are an accountant. Last week, we had a group of doctors who joined us online, a nurse, and they all did a law degree. And the point is that the law degree opens up a whole wide array of different possible careers. And you find in this next slide now, all the various possible industries for which a law degree can be put to good use. Now, by no means is this exhaustive. I am certain that there are many other professions or industries for which a law degree can be very useful for. So for example, in the area of banking, insurance, construction, these are areas, amongst others, where, as you know, they are highly regulated, where there are many laws, bylaws, regulations, statutes for which they have to comply with, contracts they have to review or go through, disclaimer clauses, for instance. And so in that regard, you find that if you have a law degree and you are from these existing industries or any others perhaps, you find that these are both extremely complementary to each other to make you the effective, competent professional in your field. And so there's no need for you to be quitting your job to work in the legal services sector or to be a lawyer. A law degree is such, it enhances whatever prior background, experience, or qualifications that you may have to make you to be more effective in your job. A lawyer can be a lawyer, but that lawyer does not have an accounting background. You may have. A lawyer can be a lawyer, but he does not have a business finance degree, but you may have. And so we do have many professionals who come from all these industries, and then together with the law degree, they then become so much more effective. And by way of an analogy, I like to always share this, and that is to put to all of you a question, which is this. You know that in your prior studies, or those of your friends that you have seen, say for example, for those who have pursued a business degree, and I'm pretty certain that when you did, or when your friends did a business degree, they would have had to do business law, company law, contract law as a subject in their business degree. The same is true for those, say, for example, doing ACCA, accountancy. There's the F4 paper that's concerning contract, corporate law as well. And it's compulsory. As an accountant, you must do law. If you're an engineer, NUS, I know that law is also offered as elective. In fact, as a doctor, they study medical and ethics law. What am I saying to you here? That in all these other fields, they study law. That itself shows how law is intertwined. essential, very much part of how it takes for you to be an effective medical professional or an accountant or an engineer. But however, think one moment further, the reverse generally is not true. Would a lawyer study medicine? Would a lawyer study accountancy? Would a lawyer study, say, finance, hotel management? Now, sure, they may, right? I know that there's some law schools now, they are a bit more liberal. They do allow electives for law students now to pick up business, accountancy, finance, and those are useful and great. But far more often, it is the other way around. It is those other professions, those other degree programs, even diploma, for example, where they study law. And this itself, I hope, allows you to see the value, the importance, and how law is integral in these professions. In a more specific manner, if you want to look at, say, for instance, some specific jobs, as it were, that you could apply for or go for, in my next slide, this will show you a wide array of specific positions or jobs for which you can maybe see yourself in based on your interests. So say, for example, for me, for instance, I enjoy teaching, and so I've been teaching now for about 20 years, and so that's me, right? But it could be for some of you now, you want to work in a bank and doing fraud investigation, and that's a huge and emerging area. As with compliance professionals, that's a big area as well. Risk management, right? So you can see how in this slide that there are so many possible careers that one could consider choosing. And so I like to say this all the time, that a law degree is not just for lawyers. And we have Simon Askey, Professor Askey, who is the Dean of Law from the University of London, and he confirms this for us. And he says that from his experience that the majority of the graduates who graduate with a law degree, right, go on now to apply their lifelong learned skills in different career pathways, beyond that of just legal practice. And so in that sense, I want to assure you that as you're watching us on this preview, that you are making a first step in the right direction to finding out more, and to now assure you that a law degree is one that's really, really useful, right? Now, I mentioned earlier on, I want to show you or share with you some of our past students and the kind of jobs that they are now in. And so here, for instance, you have Glenn, and he is working in the compliance sector. Of course, then we have Mano Chitra, and he's actually a trial lawyer, and he's working for the ICC, the International Crime Court. And so although you may not be able to practice in Singapore, at least not automatically, there are additional routes to it. But can you practice in other jurisdictions? Sure, of course, right? In her case now, for instance, she has gone international as such, working with the ICC, right? I also mentioned a very popular position or job that our students aspire to, and many of them end up in, would be as an in-house counsel. And so we have two of our younger students, Jean, right, and Derek, and they work as in-house counsels for their companies. Even outside other sectors, outside legal practice now, we have some of the more mature candidates joining us for a law degree. Chris, he was rather, a partner of PricewaterhouseCoopers. He retired, I think, last year. And in fact, when he joined us for the law degree, both him and Punit, right, as you see in this screen now, when they both joined us for law degree a couple of years back, they came along with their long string of credentials. They had their professional certifications, they have their first degrees. I think in Chris' case, he had a postgraduate degree as well. They were established in their careers. They were high flyers, as it were. They didn't need to have a law degree to enhance their job prospects. They were well established. But yet, they saw the value of a law degree. And at that age, at their age, right, they actually came back to study part-time with us, and have now completed a law degree. And if you were to reach out to them, they will openly share with you how they found a law degree really useful. In fact, we invited Punit to join us for an online conversation series a few weeks ago on a weekend, Saturday. And he was sharing, right, publicly how he found a law degree to be extremely enjoyable. And in fact, although he was already established in his career, he openly said that it opened up even far more doors for him, right? And if this is what a law degree can do for those who are established in their careers, what more for those of us who are starting out? in wanting to choose a course to do in our careers, right? A few more. So we have Yu Leong in the banking finance sector, and we have Joshua. And Joshua, as you can see now, he is working for our Singapore government. So please don't be mistaken. When I said to you that a law degree is in general not recognized for practice, please don't mishear me and think that I said it's not recognized in Singapore. No, it's not. It is recognized in Singapore, and Joshua himself, with this law degree, is working with the Singapore government, and obviously he sees a value and is putting his law degree to good use, right? So one more time, I want to just share that a law degree is not just for you to take one route, one road to end up becoming a lawyer. Now, however, it may be that you're watching this and you really want to become a lawyer. And to borrow a Singapore term, you die, want to become a lawyer. So yes, there are, I suppose, a diverging longer path that you can consider. And so let me just share with you briefly some routes of what you could do, which our students have traveled, and they have now successfully ended up in practice as a lawyer. And even though they did the law degree with us in our school in Singapore. Now, what are some of these possible routes? The first route would obviously now be where you apply for an exemption by the minister. If you look at our current law, whilst they say that it is not recognized as a qualifying law degree, they go on to say that on a case-to-case basis, candidates may apply for exemption for their law degree to be recognized as a qualifying law degree for purposes of admission to the Singapore Bar. And so, is it possible? Yes, it is. In fact, our students have successfully done this. And the way it looks will be roughly like this, where obviously now you will start off with your usual pre-U qualifications, and your law degree is in general, a 3-year program. I say in general because there's a fast-track route where it's only 2 years. I'll share more on that shortly afterwards. But say for now, it's a 3-year degree. It's year 1, year 2, year 3. And when you complete your 3-year law degree, before that, if you are watching and you have your O-levels, you are actually eligible to joining us straight for our Cert HE, for the Certificate of Higher Education from the University of London. And that is equivalent to year 1, right? So in that sense now, this is a very appealing route for some of you who have your O-levels and you don't know what to do. Consider, right, finding out more from us about your Cert HE and so-called jumpstart your legal studies. In fact, the other so-called jumpstart to a law degree will be if you or your friends hold a Temasek Polytechnic diploma, in specific, the diploma in law and management. Now, that is a great program because you do a lot of law subjects, and because of that, it is recognized, right, currently now for you to, with that, go on straight to doing the advanced diploma in law with us at BAC, right? Because you've done so many law modules already, you are recognized to go straight to year 2, which is the advanced diploma. You do now 1 more year, and that's it. You now have your law degree, right? Now, the moment you have a law degree itself is where you can come out to work. As I said just now in my earlier slides, there's so many career options that one could consider with a law degree. But of course, right, you want to practice. So what would it take for you to practice? You know, make sure that the career path that you're choosing, and in this slide, I'm showing this to you now, where it's a relevant work, relevant legal experience, relevant enough for the minister to consider you in your application for exemption, where at his discretion, he can allow you now to proceed to taking the Singapore Bar exam course. And then with that, you do your practical training. And every lawyer in Singapore goes through this. And at the end of it all now, then you can end up in practice, right? So the law degree itself is an academic degree, but the legal profession that you aspire to join has their own profession exams. In Singapore, this will be the Singapore Part A, Part B examinations, as well as the pupillage, as they were now the training contract. And then when you complete that, that's it, right? You can end up in practice. Several weeks back, we had some students whom we invited again online for a Zoom session. It's on our Facebook Live, on our YouTube channel. Google us and watch the episode where these were our students who shared their journey and how they ended up in practice with the UL law degree, right? So The other route would be where you want to practice as a foreign lawyer, and the beginning part is the same, right? You do your 3-year law degrees, okay? But now here is where, as you can see now, my point 2, your route to practice is not to be admitted to the Singapore bar. The difference between this route I'm sharing and my earlier is that this is concerning practicing as a foreign lawyer, where you're gaining admittance to an overseas jurisdiction bar. And so the way it works now would be that when you finish your law degree, you would then again, of course, be able to come out to work if you want to. But if not, right, you could then either concurrent or after that, you can then do the bar exam courses of the particular country that you choose to want to qualify for practice. So I just mentioned 2 of the more popular ones, the UK BPTC or the Australia GDL, but it could be Canada. I recall having a student who did with us a law degree, and right now he is in practice in Canada, right? So in that sense, it is recognized, right, for those countries. So you would do the bar exam courses in these countries, say about 9 months, and in which case now, with that, with your relevant work experience in that country, and then you come back, you take your Singapore Foreign Practitioners exam, and that's it. You now qualify and can call yourself to be a foreign lawyer. In which case now, you will be a lawyer that's recognized in the home country for which you had taken the bar exam course, but you can be employed in Singapore by a Singapore international law firm to be handling certain types of work as a foreign lawyer, right? And so that's another route. And again, in that conversation series I mentioned just now, we had one student who also went through this route. You can hear her experiences as well if you look up on our Facebook Live the previous recordings. The third session would be this, where this is the one that I think many of you are aware of, the JD route. JD stands for Doctorate in Jurisprudence, and that is a postgraduate law degree. In other words, it requires you to have a first degree first, right? Now, so what happens is that your first degree, in our case, would be, of course, the law degree. Now, if you already have a first degree, then you can, if you wish to, already apply to doing the JD program. But otherwise, you can join us, do the law degree as your first degree. And with that, you then qualify to apply for the JD program. And what happens is that this will be offered currently by SUSS or SMU, right? It's about a 4-year program, right, if you're doing it part-time. And so when you complete the JD, Doctorate in Jurisprudence, that is the qualification that is recognized by the Singapore government for purposes of practice in Singapore that will then allow you now to proceed to taking the Singapore Part B examinations and then to doing your pupillage, your practical training, and that's it, right? You can now be called to the Singapore bar. So this is where you end up practicing in Singapore as a Singapore lawyer and called to the Singapore bar. Only thing is this, that the route, the journey can be pretty lengthy, because you can well imagine that you do 3 years of a degree, say for example, a law degree, and then another say 4 years of the JD. It's 7 years. But whilst it's long, again, we have had students doing it successfully. Facilia, for example, she joined us on the Saturday recording session a few weeks back. You can again hear her journey on our Facebook Live session, and that's what she has gone through, which you can as well, if it's really your passion to want to end up in practice. And why not, right? The final route here would be for those of you who would actually want to get a recognized qualifying law degree that's recognized by the Singapore government. Sure, you can, right? And that's where you then will have to complete your law degree overseas. And the way it works would be, again, the basic framework is what you're seeing here now. And the difference is this, that you will say join us for the Cert HE program. Cert HE stands for Certificate of Higher Education. It's offered by the University of London. And because it is a UK university and it's a prestigious university, it's a recognized qualification for purposes of law, for applying for you to study law in different UK universities. And you want to do that, right? I want to stress now that the idea is that you want to use Cert HE to go overseas to study, right? And it must be 3 years full-time overseas law degree, and it must be in one of the recognized list of universities. Singapore government has indicated a list or a specified schedule of universities that you have to study in. And then with that, you have now a qualifying law degree. And by qualifying law degree, I refer to what qualifies you to taking the Singapore Bar exam course, right? In which case, when you finish that, Part B and your practical training, and then you'll be called to Singapore Bar. But at any point in time, in fact, in all my slides, in the last 3 as well as with this, you see that yellow box, which I'm showing you. And this yellow box is this career path that you could already embark. So I'm not saying to you that you have to do a law degree to practice. I'm saying that yes, there's the further route that you could take that you would want to be aware of. But at the end of the day, as I have been stressing, right, this whole morning, a law degree is not just for you to become a lawyer. You could already put your law degree to good use, as with many of our students. Earlier on, I showed you the pictures and names and the positions of all our ex-graduates, and many more, of course, that we have, and they are not in practice, and they are working and established in their respective career fields, right? So with that, I hope you have a good sense, right, of what you can do with a law degree, the industries, the jobs for which a law degree can be useful for, as well as if you do want to practice, how is it you could end up in practice, right? Now, the third thing this morning, which I want to talk about, would be the courses that we offer here at BAC. We don't just offer law programs, but based on the inquiries we have received the past 1 week, many of you have shown interest in doing a law program. And so I want to spend a bit more time now on the law courses, right? Although, of course, we do have some other non-law programs as well. We will have 2 main branches, so to speak, of or pathway you could pursue. One is with the University of London. The other would be with BAC, with ourselves, where you can do this a diploma and a master diploma. And as you can see here now, that it's a recognized qualification for you to then complete your final year top-up degree with a UK university and to get a law degree from that university. At the moment, our diplomas are recognized by well over 20 universities in the UK. And so you can choose whichever one you want, and then you get a law degree from that university. I'll share more on this shortly afterwards. But let's start off now by examining the UOL pathway, the University of London's pathway. And it's not a strange name. Just now, when I began the preview, we showed you some videos, some testimonials of students who have done the UL program. It's a global, international degree. It is not a strange name for many of us, right? And so that is the kind of prestige or background that we are looking at insofar as this university is concerned, right? There are many people who think, well, but this UOL isn't an actual university with a campus. And the answer is yes, right? It's a proper university. As you saw in the previous slide, it's currently the largest public UK university, right? It's obviously with its campuses. And the way it works is that they operate under a federal model, where within UOL, they have specific colleges, schools, universities. And depending as to what kind of degree you want to pursue, you then go to the specific school, college, or university. And so, for example, in this slide now, and these are not strange names to you, King's College, London School of Economics, LSE, right? UCL, Queen Mary. These are all under the umbrella of the University of London. And as you know now, they are ranked top 5, top 10 in England for their programs, in particular for law. And that is the kind of program that we are offering here at BAC. The difference, of course, is that you are not going over to UK, to UCL, or to Queen Mary to study. You are doing the UL degree here internationally in Singapore, right? And so that's how it works, right? When you do join the program, and in case you're wondering, well, then will I get the same kind of support if I studied overseas, right? I want to assure you that the program, and because it's offered by the University of London, they will give to you the same resources that they give to their students on campus, right? In fact, the materials are pretty much developed by the same academics. So they would pool together all the academics from the law faculties at UL and use their materials, resources now to be offered for those who are doing it under the international program scheme. And so some of the things that you'll be getting on the program, for instance, now would be an access to learning portal. Obviously now today, we are very familiar with virtual learning, right? And you have subject guides, posted online, you have articles. One of my favorite things which I like to recommend students to look at would be the past year exam, not the papers, but the past year exam reports. Literally for every past year paper with all its specific past year questions, the markers who have marked those papers will have a breakdown, a summary, a report of the past year paper and all its questions in a particular paper, and it goes all the way back to the past 5 to 8 years. Now, what am I saying here? That you are not alone. They hold your hand. They provide you with materials. They tell you, right, for instance now, that, well, in that particular question, students should have done this instead. This was a wrong approach. This case should be mentioned. It's a pretty extensive report, so to speak, and that's great because it gives you guidance to know what the markers are looking for and how you can then accordingly prepare and plan your materials to also answer the question in similar manner and doing well for the exams, right? The last item that you see here, which is online library, that's available also to all our students, either on the BAC diploma program or on the UL program, where we grant you access to LexisNexis, to Westlaw. And if you are a paralegal or you work in a law firm, you would have heard of these names, LexisNexis, for example, or Westlaw. Why? Because these are actually subscription paying sites that law firms pay money to access, where on these online databases or portals, you will have thousands of cases, of articles, of materials, of updates written by lawyers, judges, academics. And it's a whole wealth of online resource that lawyers or law firms use to research and to prepare their cases for their clients. Now, it's a paying site, but for our students at BAC, for those doing the UL program, for instance, it's given to you as part of the package. And so it's an amazing resource, right? Everything available at your fingertips, right? And so that's what UL provide you when you enroll on the program. Insofar as how your pathway would look like. So assuming now you say, okay, fine, it sounds good, but what's my journey going to be like? Is it a 3-year program? You said just now it's a 2-year program, which is which, right? Let me now share with you the pathway, and starting with what I'll call the standard entry, which is 12 subjects. And the standard entry, 12 subjects, we recommend it's done over, say, 3 years. And it's, say, for example, 4 subjects every year. There are some subjects that are compulsory. There are some that are optional, right? But the first year, for example, which is known in UK as level 4. Level 4 is the year 1, right? You do 4 compulsory subjects. You only begin to choose electives in your subsequent years. Now, but the great thing about these 12 subjects or this proposed 3-year plan is that it's not cast in stone. It's for you to determine and choose how you want to complete your law degree. It's highly flexible. And so, for example, as you see now in this slide, you can choose to do it over 4 years, 3, 3, 3, 3. That's it. You have a law degree. Not just that. They give you 6 years to finish a law degree. You do your math. You can do 2 subjects over 6 years, and you get a law degree. But don't do that, right? It's like a marathon, right? You tie out before the end of it. I think the 3 or 4 year would be quite ideal. But again, it does not need to be 3 or 4. It's flexible because they have 2 examinations in a given year, which is May and October. And so you can plan. Maybe May you do, say, 3 subjects. October you do 1 subject or 2 subjects, right? You can plan your studies. And so long as you finish all the 12 subjects in a 6-year period, you will end up with a qualifying law degree where it qualifies you to practice in the UK, which I mentioned just now. Now, if you are here and you already have a first degree, that's where then you can qualify for the 2-year route I mentioned just now. And this is what we call now the graduate entry program, where that has only 9 subjects. And for these 9 subjects, again, we suggest maybe over 3 years as well, 3, 3, 3. Again, the first year, they're all compulsory, right? It's the later years for which you have some electives or option papers. Again, it's highly flexible. You can choose to do it, say, for example, 2 subjects a year, or the fast track one, right? Which is 4 plus 5. So it is very possible for you to do now your law degree in just 2 years. Your first year is 4 subjects and 5 in your final year, right? Again, same thing, you have 2 exam periods. So broadly, what I've shown you now is the course structure, right, of how the UL law degree would look like, right? Now with that, I want to now move on and share to you about those of you who have inquired with us on our BAC diploma. And so you can see here now that we have also a year 1, year 2 that articulates our results or leads you to the final year, top-up degree. You can pursue that with our partner universities who had recognized our diploma now for you to get a law degree from them. And roughly how it looks like will be as follows. You can start off, of course, with a foundation course. It's a preview program, and we're at 4 subjects, right? So for instance, if you have your O levels, you can start off now with this foundation in law. Then you go on now to doing a diploma in law, which is equivalent to year 1. And if you look at the title of the subjects, common law reasonings, contract law, crime, public, they are actually the same subjects as the UL students, right? Same subjects. Then with that, after 8 months, you then move on to year 2. And that would be where you now do your advanced diploma. Again, you do your 4 subjects, right? And with that, that's it. You would have done with the year 2, move on to doing your final year. Now, how would it look like in totality? Let me show you now this particular slide. So you start off with the foundation. As I said, now you then do your diploma, advanced diploma, and then you can choose well over 20 universities that you want to study from, right? But it may be that you are seeing that, well, but David, I don't want to go overseas, maybe because it's a part-time thing for you, and you want to do the final year top-up here in Singapore, right? And it is also possible, right? So we have a collaborative arrangement with these 2 UK universities, where by the time you reach your final year, the 3rd year, you can do their law degree here in Singapore. But if you want to study on campus with them or with other UK universities, it's also possible, right? Why not? Spend 1 year overseas as opposed to 3 years, right? Spend 1 year overseas, you come back and you have a UK law degree. But again, I want to repeat what I said at the beginning. Even this route, whilst you do end up with a UK law degree, it is still, in general, not recognized for practice. Neither the UL route nor this route, whilst you have a recognized UK law degree where you can practice in the UK, but in general, you can't use it automatically here in Singapore. For you to practice Singapore, what I've shared just now were the diverging routes or the longer path that you can take to end up in practice, okay? Now, however, it may be that having heard from me now about these 2 routes, that you still feel that you want to do the UL route, or maybe you are unsure, right? And for those of you who are unsure, this is what I would recommend you to choose or to do, and is to start off with us on a diploma program. Why? Because with that, you can continue on with the advanced diploma, and then with the final year top-up with Hertfordshire or with Essex University. But it may be that at that juncture, having finished your diploma, and you feel that you want to now switch midstream now to doing the UL program, you can. Hot off the press, early this year, UL made an announcement, and it's a great news for us really, that the University of London, as of this year, recognizes our BAC diploma for entry onto year 2. And of course, with that now to year 3. It's a great thing, right? There's now that flexibility for our BAC students to doing now the diploma and either move on to doing our BAC advanced diploma or to doing now the UL program. And then, of course, you'll get a UL degree. And so you can see how there are all these permutations or variations as to your journey and how you can end up now with a law degree of your choice. In the event that at this juncture, this is all information overload and you don't know which one to choose, let me just attempt to summarize for you in my next slide. More or less what you can look at as perhaps factors to consider to choosing one that fits you for your lifestyle or your circumstance. So for example, the diploma route. Some of the characteristics as to why this may be the one that you want to choose is insofar as entry requirements, because this is a BAC diploma or diploma, and we're able to see your application, have an entrance exam with you. We are able to admit mature students, for example, onto the program, right? So in that regard now, because it's our program, we will administer and we have the capacity to interview you to see whether are you eligible for the program. And so in a sense now, it's a bit more flexible insofar as entry requirements are concerned. As with, of course, it's faster. If you have worked out the timeline just now, when I showed you the slides, you find that the UL program, it's longer. You study 1 full year, year 1, year 2, year 3. Whereas for our basic diploma, it's 6 months. So it's 8 months, and the final final year top up is about 9 months, right? It's shorter. Of course, the final reason or characteristic of the diploma from BAC is that the assessment is based on coursework as well as exams. So it's a healthy blend or combination of 2 assessment methods, coursework and exams. Whereas for UL, in contrast to those points, is that the cost, you would want to factor in fees you're paying to UL. This would be for registration as well as for examination. So there's this additional component of extra fees you pay if you are joining on that UL program. Those fees you don't pay if you're on a BAC route, because when you are doing with us the first 2 levels, there is no university fee you're paying for, right? So that's why in the sense now there are some cost savings you can enjoy. The other difference is, of course, for UL, they have this currently, it's a fully exam-based assessment. It's a 3-hour written examination, and you answer 4 questions out of 8, right? There's no coursework, no project work, no assignment. Do or die on a day, you take the exams, you pass or you fail, right? Your typical UK examination. And so those are the differences. And depending as to what is it that appeals to you, you then choose whichever you want. Of course, last but not least, if you look at my slide here, that the BAC diploma will lead you to primarily the degrees from either Hertfordshire or Essex. Whereas, of course, the UL pathway, you end up with the UL degree. And so I think this slide hopefully will help clarify or for you to visualize what is it that you want to achieve for yourself at the end of your law degree. Now, whilst you are looking at this slide or hearing from me, I don't want you to be mistaken to think, hey, David, you're trying to push us to do the BAC diploma. Based on the box for the BAC diploma, all the good points. On the box for UL, all the bad points. No, please do not mistake me. I'm not saying which is the better one. I'm just describing it as it is. These are the characteristics, objectively, the features of the respective programs. It's not whether it's good or bad, right? For example, let's talk about the fully exam-based component. Now, there are some people who prefer that. Honestly, as one example, I prefer that. I'm lazy, I don't like to be doing coursework. What assignment due next week? The next semester, another project. Next semester, another project. I mean, that's not me. I far prefer now to burn the midnight oil to study last minute for an exam the next day. Now, that's me. So if I were to choose, I may choose the UL program because it fits me. And that is what I would like you to see, that I'm not saying which is better. I'm describing you the features of the respective pathways, and you see or decide for yourself which is the better program that suits you, which is the end university that you need to end up with a law degree. Is it from UL or is it from the other UK universities? And I think that would be, in finality, really a very good assessment or question that you can ask yourself, which is, which university do you want to end up with in your law degree? UL or all the other 20 over UK universities, right? So with that, we want to now quickly move on to look at what we provide. So whether it's the UL program or the BAC program, at BAC, we have been around for about 20 over years. We are a specialist law school for so many years in the past. We only offer law programs. It's only this year now that we were acquired. We now belong to a much more larger global group of colleges and schools. And so we are now having the capacity to offer more programs. So what do we offer you when you join us for the program? Obviously now you will get comprehensive lectures and tutorials by our faculty members. So for example, by the way, I teach the law of contract for year 1. I teach commercial for year 2. I teach intellectual property for year 3. And I'm a full-time staff. And so you can you should be seeing me, right, for those subjects that you're doing. So myself and my colleagues, we teach on the law program. And the second feature, or what we offer you, would be our lecture notes. And these are materials or notes that we have edited to provide you, to support you in your studies. Now, no doubt you'll be getting, of course, your textbooks. But you do know, right, law textbooks, how they are. Law textbooks are great books to read just before bedtime. Now, it's a joke or not, but the point is that we recognize that sometimes, for law students, that you want to have bite-sized, exam-focused, student-friendly kind of materials. And that's what we give you, right, in our lecture materials. Of course, we compile past questions and we do them in tutorials. We video record all the lectures. It used to be only audio, but now with COVID-19, we will record all the lectures video. In fact, during this period of time, until the circuit breaker is fully lifted, we will maintain business as usual, but we'll maintain our classes online via Zoom, right? So live still goes on for us, and we will capture the recordings on video. In case you missed the class, you can still watch it. And all this will be uploaded on our learning management system, or LMS, to show you now what will be there. On the LMS will be all these different resources. You can access, with the BAC email address, access, for instance, now, LexNexus, Westlaw, right? What I said just now, all the databases that law firms access, you can also get to access. You can see it now, LinkedIn Learning. It's a great resource. It's normally where you pay to attend courses or classes, but now it's part of what we provide you if you have a BAC email account. And all this will be accessible via our learning management system, right? As I mentioned now, we will also be able to teach online. We populate the portal with answer guides, with charts, with revision materials, with past questions, with MCQs, how to study, right? Videos, audio. It's a very robust online portal to support all our students. Again, regardless, whether it's URL or diploma, these are the things that we offer to all our students, right? One final slide on what we offer you at BAC. We have this SASSY scheme. It stands for Student Assistance Support System, where it's a support system that we have at our school, in that we've given instructions to all our teachers to always be available to respond to students and to all their queries. And that is why most of us are actually full-time academics. We are full-time because it's only then that we're able to respond to a query. So for example, if say during lunchtime, you want to drop by the school to see a lecturer, please do so. You want to make a phone call to have a consultation with a lecturer, please do so. You and some friends want to form a study group and meet up with a tutor or lecturer to go through some points you did not understand in the class, please do so. And so that is, in a way, an instruction that we have given to all our staff, to all our teachers, to support our students. And this is something we offer you when you join us here at BSc, right? We have mock examinations and assignments as part of our formative assessment to lead you to, of course, your final exams. Very useful, especially for some of you here. Perhaps you are a mature student, and the last time you sat down to write an examination could be 15 years ago, so it's tough, right? Getting back into writing an exam answer. And so this will help. It's all part of our way to supporting you in your journey so that you are ready for the final examinations. Together with, of course, giving you practical things like answer guides, like charts. Many of us can write well, but writing well and writing a low answer, they are different. right? And so in that sense now, we prepare you in a practical slant, right, with answer guides. How would a law question be attempted, right? And for you now to also write similarly. And we have our intensive revision course. It's part of the program that allows you to then be prepared for the examinations. And finally, of course, we do invite on occasions UK lecturers, right, to conduct guest lectures. All these again extra things we're giving you, extra lectures from UK, no further charges, it's free, right? Whatever fees that we have told you or that you receive from us, it's a one fee, no other hidden charges. Of course, where we are not able to fly in the UK lecturer, we will conduct online lectures. In fact, for the past 2-3 weeks, we have had UK lectures being broadcasted, right? And all this can be made available, of course, to our students, right? So I've covered, I think, quite a bit of things. But let's look at some pictures as to who we are and life at BAC. So here you see this picture now of some of the activities we have, parties, conferences, sports, social charity events, right? In particular, I want to just highlight now the bottom right picture. And you have these people now like doing a debate. It's like they're in court, right? That's actually our classroom. And that's a moot competition. It's something that we organize every year, something which I want to now highlight especially because a moot competition is our annual event, and it's a great way for our law students now to learn advocacy skills. Now, what is a moot? And what is a moot competition? A moot, really in simple terms, is like a mock trial, where you and a partner will represent the plaintiffs, and then the other side, two of them represent the defendants. Will give you a case, and very often the case is like, it's actually a very close past-year question, for instance, and then the two teams will prepare, research, present, and argue the case before a judge, and to see who would win. It's not a real judge, it's a fake judge, right? Me, for example. And then we will decide who wins or who loses. And the whole idea is that you will then, in some sense, experience what a counsel, what an advocate will go through. Now, in case you're thinking, well, you know, David, I don't plan to practice, you know, I just want to do a law degree for knowledge. No doubt that's great, but the moot competition is extremely useful still to equipping you with skills that you can use whether or not you are a lawyer. For example, doing research. For example, now writing arguments. For example, presenting arguments. For example, responding to arguments of the other side. Are these not things that we all do at work, whether or not you are a lawyer? And so, therefore, moot competition is what our students in the past have enjoyed and have found really useful. And that's also part of some of the activities that we do here at BAC, right? So with that, I think we want to have some time to take some question answers from all of you. And so the fees, I won't go through with you. You should have the fees with you. If not, drop us an email, drop us a query, and my colleagues, myself, will respond to your query concerning the fees. Otherwise, of course, do take note that we have an early bird discount. So do find out more about that and to see how to qualify for that for our current June intake. Our intake is commencing June 15th. So you have these 2 weeks now to find out more to see whether is this what you want to look at, right? I said just now that we have other courses, the non-law courses. So for example, we have in media, digital transformation, entrepreneurship. So if you have friends who are interested in the non-law program, thank you so much. Please do share to them about BAC College. We do have these courses available as well. Just that we're not expanding more on that for today's session. Quick announcement. I've been seeing this, Zoom Saturday online conversations with our students. It's happening every Saturday at 10:30, right? So please do join us. We have one coming up this Saturday. We'll email you, or you can drop us a note to say you're interested. We'll send you the invite link, right? It's on Zoom. Yeah. So with that, I want to just pause a while, right, before we proceed to the trial lectures. That's where my colleagues and myself, we will teach you a lesson. We will share more to you about what studying law is about. But before that, right, I know you're muted, but if you have any questions at the moment, you can unmute yourself, and either myself or my colleagues who are with me online now on Zoom, we will assist you with your queries. Or if you're shy, you can just type in the answer. Maybe you don't want us to hear your voice, or your background is not very suitable, very noisy background. Type in your questions. As with the Facebook participants, thank you for watching us on Facebook Live. So any questions, please type it in. My colleagues are online with me. They will read your questions, and they will either respond to you on your Facebook chat, or they will come online to Zoom and to assist me to responding to your queries, right? So any questions? You can unmute yourself if you have any questions.
Yes, hi, good morning.
Hi, good morning.
Yeah, as regards to the 6 universities or colleges you mentioned just now, you said they are under the same umbrella of University of London, am I right?
That's right.
Well, so this degree is offered from them, or what? I don't understand this part.
Okay. The actual final parchment, the award, the degree you get, the paper you get, really,
Right.
would have the University of London's logo.
Right.
It will say UL, obviously. It will be
Right.
signed by the Vice Chancellor with the university seal. And on that parchment, it will not mention Singapore. It will not mention BAC. It will be the identical certificate that a UL student would also receive if they studied this same program in the UK. However, there is one difference, as in that if you had, say, studied law at with King's College,
Right.
Queen Mary, then apart from the UL logo, you also have the UL and then the college that you went to, which King's College. So in that regard, because you are not, strictly speaking, a King's College student, your degree wouldn't show that logo lah. But what happens is that in UK itself currently, there are many UL students who are doing the same program in England. And so what they get is what you get as well.
Okay, actually, I have intention to go to England by probably 2 years' time.
Sure.
And so I may take up the course probably in on campus 2 years from now. So is it so do I get the same kind of certificate where they get it on campus? Is it the same?
Okay, when you say that you plan
to admit to any of the college to continue or whatever.
Okay, yes. So assuming that you are able to get admittance to study law in one of the 6 law schools, because you have studied with them, you will get their degree. Yes, you will.
Okay, let me rephrase. I think right now, let's say I have A levels and I can get it done. I can get entry for this program right now, I suppose so. 2 A's, right, and 3 O's, you can get entry to this program, am I right?
That's right.
Okay, so let's say 2 years time, on my 3rd year, I'll be moving to London, for example. Then can I use this 2 years results to get entry into, let's say, King's College? I mean, convert to become the internal student?
Okay.
David, I can help with that.
Yeah, sure.
Hi, Vincent. My name is Anandi.
Hi.
Ordinarily, when you actually want to transfer internally to a university in the UK, you will not be able to do it in the final year. So at best, you would be able to only transfer after doing 1 year. You can transfer to go on to do your 2nd year. But that actually depends on each individual university's criteria. So although the University of London umbrella, all these universities come under the University of London umbrella, each of the colleges under the University of London have their own entry criteria, you see? Yeah, so that's how it works.
So in other words, even if I finish the 1st year in Singapore, if I go to on campus, they will review my case over again. Is that what you mean?
In some instances. So what will happen is, I can tell you for a fact, if you went to Queen Mary, and Queen Mary is part of the University of London umbrella, you would be able to enter into year 2. So for Queen Mary, when you finish your year 1 externally, you will be able to enter into year 2 and year 3, depending on your grades and depending on whether or not they are willing to accept you based on what you've done.
You mentioned Queen's Mary.
Yeah.
Are they the only one?
Yes, Queen Mary definitely will take you into year 2.
Okay,
The
yeah.
other universities, like for example, King's College, LSC,
Yeah.
UCL, all these, they may. I think that's how I
Okay.
would put it. Yeah.
Okay, but Queen Mary, you are quite sure about that, right?
Yes, Queen Mary will not take you into year 1 if you've completed year 1. They will
Yeah.
only take you into year 2.
Okay, thank you very much. Thank you.
You're welcome.
That's all I need to know. Thanks.
Okay, great. Any other questions from anyone?
Okay, if I may, there's actually a question here on the Zoom chat. So I'm Subra, so from BAC. So there's a Rachel who's a participant here on Zoom. And the question that she's posed is, there is now the option to go for the University of London degree year 2 and year 3 after finishing the BSc diploma. Is it possible to go for the UOL graduate route after finishing the BSc diploma? Right, that's the question. So I think I can answer that. So the University of London has actually allowed students who have done the BSc diploma to go on to second year of the LLB. Right now, that's not an indication that you can do the graduate entry route. So that's something that we will need to check with the university whether they'll allow you to go to the graduate entry. In the past, graduate entry route, because it is a 9-subject route, the university did not allow a student who's done a Cert HE to go on to graduate entry, for instance, right? So this is something that we will need to check directly with the university. But for now, what we know is that a student who's finished the BSc diploma carries on to the standard entry second year and third year of the Bachelor of Laws with the University of London.
Okay, thank you. Thank you for that. Any other questions?
Sorry, there was also a similar question posted by someone on Facebook, someone who has done the University of Malaya degree. So if you've done the University of Malaya degree, you would be eligible for the graduate entry route of the University of London, which is 9 subjects, which you can either do in 2 years, which you do 4 subjects in the first year and 5 subjects in the second year, or you do it in 3 years where you do 3 subjects per year for 3 years. As it stands, the diploma in law with the University of London, as Mr. Subra has said, allows you to go into year 2 of the standard entry route. Yeah? All right, thanks.
Okay, thank you for that. Any final questions? Okay, if not, I think we want to proceed to the next part. This is a part that some of you had indicated that you want to watch, which is the law lectures from us. And what will happen is that my colleagues will come in and take over the session. Ms. Anandi, she's online. She teaches criminal law. She's actually a principal of our law school. And so she will take about, say, 20 minutes to talk about criminal law. And then Subra will come in to talk about his subject. And then we'll end the session with the law of contract, where the third subject I will then come back on to talk about the contract law, right? So with that, I just pass the time over to her for her to share her screen with you and to take over the next part of our session.
Thank you, David. I'm here, my name is Anandi, as you would know, and I'm going to talk to you a little bit about the subject of criminal law. Criminal law is a compulsory subject that you have to study in the University of London or the BAc Diploma in Law syllabus, because criminal law is considered one of the core subjects that you need to do in the UK for a UK law degree. Yeah. So criminal law, as you would all imagine, is rather interesting okay? Because, you know, you watch Suits, I'm sure, more recently, and if you're closer to my age, you probably would have watched LA Law. And all this creates a very interesting, sexy view of criminal law. But I am actually here to sort of burst your bubble, because I'm going to tell you that when we're looking at the study of criminal law, we are actually looking at the theory of criminal law. Yeah. And when you look at the theory of criminal law, what we're looking at is the question of when is a crime committed, as opposed to the practice of criminal law that deals with the question of how is a crime committed, all right? How to prove the commission of a crime. Now, that's interesting. Not just interesting, it's also really important. Yeah, because a person cannot be convicted of a criminal offense unless you can prove beyond a reasonable doubt that he has committed a particular crime. But unfortunately, when you're studying criminal law, you're looking at the theory and you're asking the question of when is the crime committed? And to answer that question, when is a crime committed, we need to know what are the requirements of a crime and are those requirements satisfied? All right. Now, when you're looking at evidence, evidence is important to how is a crime committed. Now, as I said, evidence is important, but that is a separate subject in itself. In the theory, you're studying the question of when. When is a crime committed? Okay. Now, when is a crime committed? Now, if you look at the language that I have here on my screen, you would see that this is not language that you're familiar with. You don't watch it on TV. It was definitely never mentioned in Suits or in LA Law, okay? The term actus reus, mens rea, you don't see this kind of language. Now, the reason is, okay, again, I reiterate, the actus reus is the guilty act. The mens rea is the guilty mind, and both of this combined makes an offense, makes a criminal offense, okay? Now, sometimes a person, so for the simplest example, all right, if I took a gun, okay, and held it against your head and pulled the trigger, and as a result of which you died, I have committed the actus reus of murder because I have caused your death. And if I held a gun to your head and pulled the trigger, at the very least, I have, and well, not at the very least, I very clearly have an intention to kill you. So I've done the guilty act, I have the guilty mind. Now that's murder. But let's say, for the sake of argument, the reason why I held that gun against your head and pulled the trigger was because, okay, you were about to kill me. You had a gun pointed at me, and it was a question of who pulled the trigger first. So when I pulled the trigger to kill you, I actually did it in self-defense. So I killed you, I caused your death, I had an intention to kill you, but the reason why I did it is because of self-defense. So now we can no longer say that I have no defense. So if I did the actus reus with the mens rea without a defense, then it is a crime. But if I do the actus reus with the mens rea with a defense, then it doesn't amount to a crime. All right. So a crime, when you're looking at, okay, so if I said earlier, the requirements for an offense, what are these requirements? These requirements are actus reus, mens rea, no defense. Now, as I said, actus reus, mens rea, these are Latin terms, and this is not language that you would have read about or seen. But this is the language that you would need to know in the study of criminal law. All right, you will need to know what is the actus reus of a crime, what is the mens rea, and are these requirements satisfied in any given situation. Okay, so let me give you an example of this difference, the difference between theory and practice. And I use this example very often because it shows you very clearly the difference between what we're studying and the actual practice of criminal law. All right. Now, the offense that I'm going to be looking at is the offense of theft. And this is also part of your syllabus. You will be studying this much later in the day, all right? Now, theft is defined by Section 1, subsection 1 of the Theft Act of 1968, okay? Now, criminal offenses in the UK are mainly found in acts of parliament like this, okay? The Theft Act determines the offense of theft. The Criminal Damage Act determines offenses of damaging property. Offenses against the Persons Act deals with causing harm, okay? The only offense actually that you would be looking at that is not defined by any act of parliament is murder. Murder is a definition that is not found in any act of parliament. It is what we call a common law definition, a definition that was given by a judge and that has been used till today, all right? So let's look at theft very quickly. Now, Section 1, subsection 1 of the Theft Act defines the offense, and it says that anyone who dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it commits the offense, commits theft, okay? Now, and the requirements I told you is the actus reus and mens rea. Now, where does this come from? It comes from this definition, all right? So I've got that definition again, okay? Anyone who dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it, okay? Now I've broken that up into the actus reus and the mens rea, all right? So if you look at it from the definition, the actus reus is appropriation of property belonging to another, so that's the guilty act. The guilty mind is dishonesty and an intention to permanently deprive the other of it. I'm sorry, it sort of got messed up there. It's an intention to permanently deprive the other of it. So there are one act requirement, which is the appropriation. What do you need to appropriate? You need to appropriate property belonging to another. The mens rea requirement is actually two: dishonesty and an intention to permanently deprive the other of it, okay? So let me give you an example. Now, A, he walks into the supermarket, similar to the picture that I have put up there. He walks into the supermarket. He looks around to make sure that there is no CCTV camera aimed at him. There is nobody watching him. He makes sure that he's all alone and his back is turned to anyone who's there. And he takes a bar of chocolate from the shelf and he puts it to the jacket pocket. And he walks out of the shop without paying for it, okay? So what has he done? This is very simple. This is stealing, am I right? You take a bar of chocolate, you walk out of the supermarket without paying for the bar of chocolate. That is stealing. Simple, all right? Now, my question here is, and this is what in the exam you would have to look at, is when does he commit the offense of theft? Now, there are two instances where this could be done. It was either at the point when he took the bar of chocolate and put it into his pocket, or at the point when he walked out of the shop without paying for it. So he takes the bar of chocolate, that's one, and he walks out of the shop without paying for it. And as a student, you would be required to actually answer that question, okay? Now, let me explain to you how that works, all right? So, let me go back. Okay, so when A took the bar of chocolate and he put it into his jacket pocket, what did he do? He appropriated. Appropriated in its simplest term means to take property that belongs to another. So when he took the bar of chocolate and he put it into his pocket, he took property belonging to another. Now, the mens rea requirement for you to be guilty, and both the actus reus and mens rea must occur at the same time for a person to be criminally liable, all right? So if you look at the actus reus, he took it and he put it into his pocket. Now, the mens rea requirement is dishonesty and an intention to permanently deprive the other of it. Those are the two mens rea requirements. Now, let's look at it. When he put it into his jacket pocket, was he dishonest? Yes, he had no intention to pay. Now, did he intend to permanently deprive the owner of the property? Again, yes, because when he put it into his jacket pocket without an intention to pay, that is an intention to permanently deprive the owner of the property. So if you look at it, when he put it into his pocket, jacket pocket, he appropriated property belonging to another, plus he had the necessary mens rea. He was dishonest and he had an intention to permanently deprive. Now that is theft. So when did he commit the offense? He committed the offense when he put it into his jacket pocket. Okay? Now, a lot of you would have thought that the offense was actually made out when he walked out of the shop without paying for it. Okay? Now, that is important because that is evidence. Okay? So in reality, okay, when will they nab you? They won't nab you in the shop. They won't, even if the CCTV camera was watching you and you put it into your jacket pocket, or the security was watching you hidden behind a shelf and he saw you put it into the jacket pocket, he wouldn't stop you until you leave the shop. Why? Because that is evidence, proof that you had no intention to pay. Okay, because if now somebody stopped this guy and said, hey, you're stealing, I would say, how would you know? I haven't left the shop yet. I'm going to pay at the counter. I can put it anywhere. I can put it in my pocket. I can hold it in my hand. I can put it into the basket. I can put it anywhere. You shouldn't care where I put it. You should only care if I pay for it. And he's right. Evidentially, we cannot prove that he committed the offense until he walks out of shop, because then that is proof that he did not have an intention to pay. Okay? Now, in theory, when did he commit it? When he put it into his jacket pocket. So you see what I mean? When we study the theory of criminal law, that's what we're studying. And this is a similar exam question where the examiner will ask you. He saw that there was no CCTV cameras around. He put it into his jacket pocket. And as the student, you are required to tell the examiner that because the elements, the requirements of the offense, the actus reus and the mens rea is made out, at that point, the offense is made out. So when is the offense made out? When he put the chocolate into his jacket pocket. Can you see that? That's the difference between theory and practice. Okay? Now, let's say, for example, the reason why he went in and he stole those chocolates was because somebody outside was holding a gun to his son's head and said, okay, if you don't steal the bar of chocolates, that he would kill A's son, or he would cause serious harm to A's son. Okay? Now, and if that is the reason why A went into the supermarket and stole the chocolate, then although he still has the actus reus and mens rea, now he has a defense, okay? And that defense is called duress of threats. If somebody is holding a gun to your child's head and threatening harm to him, serious harm to him, and asks you to commit an offense, you have the defense of duress of threats, okay? So although he did commit the offense because he did the actus reus and he had the mens rea, because of this defense, because of duress of threats, his actions will be excused and he will not be criminally liable, all right? So it reiterates the point that actus reus plus mens rea without a defense amounts to a crime. Actus reus plus mens rea with a defense doesn't amount to a crime. All right? Okay. Now, what I'm going to do with you next is I'm going to give you just a simple teaser of a criminal law exam question and how a student is required to approach an exam question. All right? So here we have the question, okay? A comes home early from work one day and he finds his wife B in bed with the gardener, C. Furious, okay? He rushes into the kitchen, he takes a sharp knife and he stabs C with it, all right? C, as a result, okay, of being stabbed, is rushed to the hospital, okay, because A might have been overcome with remorse after stabbing C. And C is then rushed to the hospital where the doctor tells him that he requires a blood transfusion to live. And C says C refuses the blood transfusion, okay? He's barely conscious, but he refuses a blood transfusion. And because he refused a blood transfusion, he dies. The doctor tells him he requires a blood transfusion to live. He refuses a blood transfusion. Clearly, because of that refusal, he dies, okay? So now we have to consider A's criminal liability, all right? Now, A has stabbed C. C was taken to the hospital. He required a blood transfusion. He said no, he died, all right? So the ultimate consequence of A's actions here is that C has died. So we now have to consider, okay, what offense can we charge A with, okay? Are the requirements, are the elements of the offense made out, i.e. is the actus reus made out, is the mens rea made out, and over and above that, does A have any defense? So essentially, this is how you answer an exam question. What are the offenses? Are those offenses satisfied on the facts? Are the elements satisfied on the facts? Are there any defenses on the facts? And can the defendant rely, can the accused rely on those defenses? Okay, so let's look at this in a bit more detail. All right, so because A has died, C has died, the consequence, okay, is death, and therefore A will be charged with the offense of murder, okay? Now you remember I told you earlier, murder is one of the very few offenses that we will be studying that is not defined by any act of parliament, okay? It was actually a definition that was given by a judge in the 17th, 18th century. And till today we use that definition, but we no longer use the language that is used, and some changes have been made along the years, okay? So in a very simple definition is unlawful killing of a human being with malice aforethought. That's the definition for murder, all right? And that definition, as you know, is divided into the actus reus and mens rea, okay? So the actus reus is unlawful killing of a human being, and the mens rea is an intention to kill or an intention to cause serious harm, all right? So looking at it again, you can see, all right, is there, the mens rea element is actually what is easy on these facts, right? Okay, because he came home, he was furious when he saw his wife, okay, in bed with the gardener, and, you know, they weren't reading a textbook, obviously, we know what they were doing. So he was furious and he took a knife and he stabbed C with it, okay? So even if he didn't have an intention to kill, when you take a knife, a sharp knife, and you stab somebody with it, now that is an intention to cause serious harm. Am I right? So malice aforethought is defined as an intention to kill or an intention to cause serious harm. And here, what we do have is an intention to cause serious harm. All right? So the mens rea element is satisfied. Now let's look at the actus reus, and this is where in the exam we call an issue, all right? We have to show that A caused C's death. That is the most important requirement under the actus reus, because for unlawful killing of a human being, you have to show that it was A's act that was the cause of C's death. Now, what is our problem here? On these facts, we have a small problem, and that is that although A stabbed C, A rushed C to the hospital and A got him, you know, medical treatment. But it was C who refused that medical treatment. It was C who refused the blood transfusion, and C died. So the question that we have to actually answer is this: is A's act the cause of C's death, or is it C's own act that is the cause of C's death? Now, this is when you have to look at case law, and case law will help us determine the answer to that question. All right? Now, we have the case of R against Blau, and the case of R against Blau, on very similar facts actually, okay, was he stabbed the victim many times. She refused to have a blood transfusion because, you know, she was a practicing Jehovah's Witness, okay? The defendant argued that it was the refusal, okay, that was the cause of death, and therefore the act done by the accused didn't cause the consequence. The act done by the accused caused the harm. The consequence was actually caused by her refusal to consent to the blood transfusion. Therefore, there is a break in the chain of causation. The act must cause the death. The act didn't cause the death, and that's what the defense argued. The courts held no. The courts held that, look, the wound inflicted by the accused is still operating as a cause of death. Okay, the judge, he said very clearly, he said, if you ask the question, what is the cause of death? The answer is very clear. It's the stab wounds. And it's similar here. If C hadn't been taken to the hospital, would he have died? Yes. So what caused the death? It was A's act of stabbing C. Can you see that? So from that, okay, we can see that the act of A stabbing C is the cause of C's death. Okay, so is the actus reus element satisfied? Yes. So earlier we said the mens rea wasn't a problem. We said an intention to cause grievous bodily harm at the very least. The only issue was, did A's act cause C's death? And looking at the case of R against Blau, and you would learn all this. You will learn the cases. You would learn how to look for the cases. All of this will be taught in the syllabus itself. All right. So don't be too concerned about the fact that I'm talking about acts of parliament. I'm talking about cases. All of this you would study when you're in it proper. I'm just trying to give you, as I said, a little sneak peek. All right. So following the decision in R against Blau, the chain of causation is also satisfied. Am I right? So now what are we looking for? Are there any defenses? Okay. Now, you remember, why did he kill C? Why did he stab C? Because he came home and he saw C in bed with his wife. I mean, clearly they were doing the dirty. All right. So defense of loss of control, which is clearly what happened. He was provoked into killing C, or into stabbing C, I'm sorry. All right. Now, Section 54 of the Coroners and Justice Act deals with that defense, and it says, anyone who kills, if he has lost his self-control, and if that loss of control has a qualifying trigger, and a person of that same circumstances would have done the same thing, you have a defense. Okay. Now, unfortunately, Section 55, subsection 6A says, if that thing that caused the qualifying trigger, that thing that caused you to lose your self-control is sexual infidelity, now that is to be disregarded. Okay. So if we go back to our facts, why did A lose his control? Because of his wife's sexual infidelity. And Section 55, subsection 6, very clearly tells us, if the reason for you to have committed this offense, for you to have lost your control, is sexual infidelity, I'm sorry, it cannot be taken into account. All right? There's actually a very good reason why the law says this today, and I think I'm running out of time, so I can't tell you now. But register for the program, and when we actually study the Coroners and Justice Act, we will actually look at the history of the defense and to look at why sexual infidelity is something that cannot be taken into consideration, when it was something that used to be taken into consideration very readily, I might add. Okay, so in this particular instance, does A have a defense of loss of control? Unfortunately, no. So if we're going back, okay, looking at this question, A will be convicted of murder as the causation element is satisfied, and so the actus reus and the mens rea is satisfied. There are no defenses. He cannot rely on loss of control because of Section 55, subsection 6A. What does that mean? It means he will be convicted of murder. And what does that mean? It means that he will be sentenced to a mandatory life in prison. Okay? Mandatory life imprisonment at Her Majesty's pleasure. What does that mean? It means that you will be sentenced to prison for an indefinite period of time. There's no cutoff. All right? For any other offenses, there's usually maximum imprisonment. Maximum 10, maximum life, maximum 5. Murder is an offense that carries a mandatory life in prison. No more death penalty, In the UK, it's been abolished. So in the UK, there's no more death penalty for murder. It is a mandatory life imprisonment. All right. So that's what you do. You look at a situation, a question. You look at what are the offenses? Are they satisfied? Are there any defenses? And this is your conclusion. All right. So thank you very much. Okay, that's that little bit about criminal law. I hope I've piqued your interest just a little bit. And when you come in and you actually study the subject and you come onto the program, you will learn a lot more. So I started off by saying we're doing theory and it's boring. It's actually not. It's not boring. The cases are interesting. The stuff that we study is actually quite interesting. So thank you very much for listening to me. I will now let Mr. Subra talk about public law. Thank you.
Okay, hi. Let me share my screen first. Okay, good morning. Right. I will be taking you through public law as a trial class today, right? And I've chosen the topic of the rule of law to discuss with you. Rule of law is one of the more fundamental concepts in public law. You could say that when we talk about constitutional law in any country, the very fact that we commit ourselves to having a constitution and the very fact that we talk about having some kind of limitations on the power of the those who govern, we have already committed ourselves to the concept of the rule of law, right? And I always like to tell this little story about what St. Augustine had written a long time ago in the 5th century AD, right? St. Augustine had spoken, right, about the incident involving Alexander the Great, right, and the pirate. So there was apparently an occasion when Alexander the Great had arrested a pirate that was causing a lot of trouble, right? And Alexander the Great had asked the pirate, right, how dare you molest the seas? And the reply from the pirate was, how dare you molest the whole world? Because I do it with a small boat, I am called a pirate and a thief. You, with a great navy, molest the world and are called an emperor, right? And that really is, in some sense, a key issue, right? What St. Augustine was trying to show was that there's no difference between a pirate and an emperor, right? Alexander the Great is reputed to be a great empire builder, no doubt, right? But the problem with all of these emperors, kings, right, was that they were really the biggest bullies in town. They were basically just the people who went around killing, looting, plundering, right, and building their empires, right? So when we look at it dispassionately, we realize that most great emperors were not subject to any legal restriction whatsoever, right? They were all powerful. And if they chose to abuse power, there's nothing much that we could do about it. So very early on in St. Augustine's City of God, he talks about the fact that a government or a state without any restriction, without any sense of justice, is nothing more than a band of robbers, right? What are states without justice but robber bands enlarged? Just a band of thieves, right? No difference between a government and a bunch of individuals who are robbing, if in the end the state is not based on concepts of justice, if the state is not based on concepts of law. If there's no legal restriction on the king or no legal restriction on those who govern, right, then the very basis of governing itself is questionable. The legitimacy of governance is questionable, which is where the concept of the rule of law comes in. The idea that government must act in accordance with law. What I have here is a quotation from Joseph Ras. When you eventually enroll on the program and you study this course, when I conduct the rule of law topic, one of the jurists, right, one of the philosophers that we look at is Joseph Ras. And Joseph Raz talks about how the idea of the rule of law is different from the concept of rule by law, right? And he says this, in its broader sense, this means that people should obey the law and be ruled by it. So this is one sense in which we understand the rule of law, right? When we talk about rule of law, we tend to think of law and order. We tend to think about the fact that citizens must follow the law. We must adhere to the existing laws so that there is some level of stability and security in the country. That is one sense in which we talk about the rule of law, stability in a country. But there's another sense in which we talk about the rule of law. In a narrower sense, in legal theory, rule of law is more about the fact that government must be subject to law, right? So he says, in legal theory, it is read in a narrower sense, i.e., that the government should be ruled by the law and subject to it. This is often expressed as government by law and not by man, because this distinction differentiates the concept of the rule of law against that by rule by law. So for instance, we could go to North Korea and we could say that fine, in North Korea, they have a constitution, they have a set of laws. But having said that, just because you govern by using law, you can't really say that that is the rule of law, right? So the rule of law is a slightly different concept from just saying that a government acts in accordance with law, right? There are certain restrictions on what government can and cannot do. Potentials for abuse of power, even using law, is actually questionable, right? So we distinguish between the concept of rule of law as a higher concept, as opposed to rule by law, where those who will seek to abuse power may actually just use the law to justify their power, right? Now, this picture that you see here is a depiction of a scene along the Thames River. Runnymede is the place that we're looking at. And what you see here is in the background, you can see some tentage and all of that, right? There was a battle that had been fought, right? Back in 1215 AD between King John, the man that you see there sitting down signing that document. That's King John. And John was a king who had a bit of trouble with his lords and barons. He was known to be quite wasteful and he engaged in a lot of wars. And at one point in time, that meant that he had to raise exorbitant amounts of tax. So, of course, he will turn to the lords and told them to impose higher and higher tax on the peasants. The lords, at some point in time, realized this is not tenable, right? We need to control this king, right? And what he's doing. So there was a battle that was fought between the lords and the king. And eventually there was a settlement arrived at. And that is the document that the king is signing, the Magna Carta, very famous document, signed in 1215 AD. The Magna Carta, to some extent, represents in English law the first time that a king's power was restricted by law. Whereas in the past, we could say that the king is the law, now we would say the law is the king, right? So it is no longer possible for the king to act in accordance with whatever he wanted, according to his own whims and fancies. The king was now restricted by this document that he had just signed called the Magna Carta. The Magna Carta is also, of course, referred to as the Great Charter of Liberties. It's very well celebrated in many parts of the world, right? A copy of this document actually came down to Singapore in 2015, marking the 800th anniversary of the Magna Carta. And it was in our Supreme Court. They actually displayed it for 1 week here, right? So some of our students actually went over and took a look at the document as well, right? So it is no longer really a live document as such, but having said that, it represented that promise made by King John that he would not arrest anyone and put that person behind bars unless the person has first been presented before a court of law, all right? So I have this quotation here from the Magna Carta. What you see in the background of this slide is actually a copy of the Magna Carta, right? No free man shall be seized, imprisoned, stripped of his rights or possessions, outlawed or exiled. nor will we proceed with force against him except by the lawful judgment of his equals or by the law of the land. To no one will we sell, to no one deny or delay right or justice. Okay. Now, in modern terms, this proposition in the Magna Carta is referred to in a truncated form as there shall be no punishment unless there is a breach of law, right? A promise by the king that he is not going to send you and put you behind bars, right? That he will first charge you with an offense in a court of law. You'll be found guilty through a lawful judgment of the court. And then after that, you'll be imprisoned, right? So that's a very key concept in the idea of the rule of law. And we still have that concept very much enshrined in the way in which we expect the British government to behave, so that nobody is in fact arrested and convicted without trial. You need to go through the process of a trial and be convicted before you can be thrown behind bars, right? So that brings me to the concept of the rule of law that many believe that the United Kingdom adheres to. And of course, this is part of what we do in our subject as well. We look at the theory of the rule of law. Professor Dicey, that you see over here, right? In the late 19th century, he wrote about the concept of the rule of law as practiced in the United Kingdom. UK may or may not adhere to the rule of law properly, but part of what we do as an academic exercise is actually to understand the concept of the rule of law and then go on to analyze what has in fact happened in terms of case law, in terms of political events in the UK, to see whether or not the UK government really adheres to the idea of the rule of law. I am not going to go into all of the postulates of Professor Dicey, nor am I going to go into the academic controversies and the critiques. That's part of what we do when we study. But at this point in time, it will be sufficient for me to just let you know the first postulate of Dicey. And he says this: we mean in the first place that no man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. In this sense, the rule of law is contrasted with every system of government based on the exercise by persons in authority of wide, arbitrary, or discretionary powers of constraint. Quite a fair bit in there. And that's also something that we kind of go into a bit of detailed analysis in class. But for now, from this, we extrapolate and we say that there shall be no punishment unless there is breach of law. You and I cannot be deprived of our liberty. You and I cannot be deprived of our goods. You and I cannot be deprived of our life unless we have breached a law. So of course, if let's say there's an offense stating that you cannot commit theft and you have committed theft, and the prescribed punishment for that is, let's say, imprisonment for 6 years, then of course the state is entitled to charge you for the offense, bring you to a court of law, find you guilty, and then after that imprison you, right? But what they can't do is that they can't imprison you without any basis whatsoever, right? And that's the whole promise that we have under the rule of law, okay? Now, although I am not going to go into all the three postulates of Dicey today, right? But very briefly, when we talk about the three postulates of Dicey, they are basically what you see here on this slide. No punishment unless there's a breach of law, equality before the law, and judges are the best protectors of liberty. What I'm going to do in the next few slides is actually just to look at the concept under the first postulate, no punishment unless there's a breach of law. What do we mean by that? The fact that you are not deprived of your life, your liberty, and your property unless there's a distinct breach of law, and the fact that there will not be any use of wide, arbitrary, or discretionary powers by the state. That's the promise that is made under the concept of the rule of law. The rule of law is not law. The rule of law is just purely a political doctrine. We use that political doctrine to judge politicians. We use that political doctrine to judge the way in which government performs its functions, right? So, The first example I'd like to look at, right, in terms of the way in which the rule of law operates, is this rather old case, Antic against Carrington from 1765, right? The picture that you see there is an image of the sheriff having entered into the premises, ransacking the papers, right? Antic was someone who was actually a writer, and what the minister had done was that he had ordered or issued a warrant to his sheriff to enter the premises and look for any potential items that might be seditious, right? They wanted to charge Antic for sedition, right? So they were fishing for information. They couldn't find anything appropriate. So they went into the house, they unlocked the place. They took about 4 hours ransacking the entire place, right? And they took whatever they could from there. But of course, in the end, there's nothing seditious that was found, and he was not charged for anything, right? Now, of course, Antic was not too happy, and he sued Carrington. Carrington is one of the king's messengers who was actually in the premises. He sued him for trespass, right? So Carrington and his colleagues were sued for trespass by Antic, and the question that arose in court was whether or not trespass was made out, right? And of course, what the defendant's argument was, I was there with a lawful warrant. The minister had issued a warrant for me to enter the premises, so I was entitled to search the premises and take whatever property was there, right? Now, the court questioned that premise. The court said this is unlawful. A minister has no power to issue warrants, right? And the issuing of a warrant is not done by a minister. In those days, right, when we talk about entering somebody's premises, the police would have had to get a magistrate's warrant before they enter the premises, right? And the minister himself had no such power, right? So the fact that the individual purported to enter the house with the minister's warrant would mean that he had done so unlawfully. He had infringed upon somebody's property rights unlawfully, right? So Lord Camden, who was the judge in the King's Bench at that point in time, presiding over this case, right, stated this in his judgment. The great end for which men entered into society was to secure their property. That right is preserved, sacred, and incommunicable in all instances, where it has not been taken away or abridged by some public law for the good of the whole. So a concept that is quite latent in English law is the idea that our personal property is sacrosanct. Whatever we do within our personal property is our own business, that nobody can come into our premises without our permission. That is still true today, even in Singapore, right? Nobody can enter your flat or your house without your permission, right? And even the police, for that matter, right? If they're just going around asking questions, they will stand at your door. They're not going to enter your house. If at all they're going to enter your house, they need to have lawful authority to enter your house. To do so, they need a proper warrant for the purpose of entering your house, right? And this is what Lord Camden went on to say. By the laws of England, every invasion of private property, be it ever so minute, is a trespass. No man can set his foot upon my ground without my license, but he is liable to an action, though the damage be nothing, which is proved by every declaration in trespass, where the defendant is called upon to answer for bruising the grass and even treading upon the soil. If he admits the fact, he is bound to show by way of justification that some positive law has empowered or excused him, right? So the point is, if you enter into the premises, so in this instance, in this case of Antic and Carrington, right, when Carrington entered the premises, there's no justification for him to enter the private property of an individual. And he claims that the minister gave him the warrant. The court was of the view there's no law that allows the minister to do that. So clearly, there is an infringement of the personal rights of the individual. Antic and Carrington is one of many cases that we will look at, many interesting cases involving government attempting to abuse power and the court stepping in to say that, no, that's not the law. You cannot lawfully exercise those powers. And it's a reflection of this whole rule of law concept that we are talking about. And in terms of this rule of law itself, right, When we spoke about the idea of imprisonment, I mentioned the Magna Carta. I said that under the Magna Carta, King John had promised that nobody will be imprisoned unless in the first place he's presented to a court of law. That promise has held true throughout the centuries. There's this concept of due process that we have in criminal proceedings, right? That every person, when you're charged with an offense, you're presented in a court of law, evidence is presented against you in a trial, you have an opportunity to rebut that evidence, and at the end of that, the court will decide whether or not you are guilty. There's no such thing as minister decides you are guilty and you'll be thrown behind bars. That would go against the very idea of the right to liberty that is part and parcel of the first postulate of Professor Dicey, which is that no person shall be imprisoned unless they are subject to the law, right? So if, of course, you happen to commit an offense under the law, then you can be charged for that offense and found guilty. But under no circumstances can you actually be detained without trial, right? That's a basic concept that we have in the right to liberty. Now, however, it was quite shocking in the year 2001 when the UK Parliament passed the Anti-Terrorism Crime and Security Act. Of course, in the lecture, I'll be looking at quite a lot of other instances of potential abuse, but I'm highlighting this particular incident because in the year 2001, the 9/11 attacks took place, right? And when the 9/11 attacks took place, in the UK itself, the UK Parliament passed this particular law, Anti-Terrorism Crime and Security Act, introducing indefinite detention without trial. It was particularly shocking, at least in the academic world and those who are concerned about human rights, it was very shocking that the UK would pass such a law within their own territories, right? And so then subsequently what happened was the law was challenged in a court of law. In the case of A and others against the Secretary of State for Home Department that you see over there, there were individuals who were detained without trial under that particular law. The picture that you see there is a picture of Belmarsh Prison, right? Belmarsh Prison is where some of these guys were actually detained without trial. The minister alleged that they were terror suspects and they were detained indefinitely. That was challenged in a court of law. The case went all the way up to the highest court in the land, and the court decided that the Anti-Terrorism Crime and Security Act was not compatible with Article 5 of the European Convention of Human Rights. Now, those things are matters that we learn as part of the syllabus. We learn about the European Convention of Human Rights, the different articles, and there are occasions when there's infringement of those articles by the government, and the UK courts are called upon to make a determination on that. And in this case, what the court did was they declared the law to be incompatible. But unfortunately, the United Kingdom does not have a written constitution. The courts do not have power to declare a law to be invalid. The most they could say is that the law is bad law, but it's still valid law, right? So they say it's incompatible legislation. We were left with Parliament to decide what to do. To be fair to the UK Parliament, 2 months after the decision was made in the case of A and others, Parliament went ahead to change the law and they removed the provision on detention without trial. So for a brief period between 2001 and 2005, UK in fact flirted with the idea of indefinite detention without trial, when all the way from 1215 AD, the promise had been made that nobody will be imprisoned unless they were subject to the lawful judgment of their peers, right? But we're back to square one again. We're back to the position that, yes, nobody will be imprisoned unless they are, in the first place, subject to the lawful judgment of the courts, right? Now, kind of running a little bit out of time, so I will end my session on this rule of law topic at this point in time, right? And I will hand over to my colleague, who is Chung, right? You saw him earlier, David Chung, and he will take you through contract law. And after that, we'll do a short Q&A again. Over to you, David.
Hello, hi. Thank you for still staying on to now with us. And we want to look at the last subject for our trial class for today. And I teach law of contract. And in my opinion, of all the 4 law subjects that you'll be doing for year 1, that I think that the law of contract will be your favorite subject, the one that you'll find most interesting and most exciting. But of course, I'm biased, right? But when I say that contract law is interesting and that you enjoy or find most relevant, it's primarily because the law of contract would be likely the subject that will be able to relate to you and to me in a very personal way, because we all make contracts every day. Now, when I say that we make contracts every day, it's true, isn't it? That if you had, say, bought breakfast this morning, you have made a contract. Currently now, you have a broadband service, you have a contract. Over the weekend, you may buy a pair of shoes, you go for a haircut, you've made a contract. You take a train or a bus, you've made a contract. And so we are surrounded daily with contracts that we all make. Now, the examples are given, obviously, the so-called simple contracts. We are familiar with the other types of contracts, the more serious ones. For example, many of you are working, perhaps, and you have a contract of employment. That's a contract, right? You have insurance policies. That's a contract. In case if you are married, in some sense, isn't that also a contract where the 2 parties together signed before witnesses, before an official, the registrar of marriages, to sign to say that we want to be in a covenant, to be in a contract together for life? Even a marriage, in a sense, has its basis in contract law. And so to the extent that's why contract law is the one subject that many of us are able to relate to, right? As I start off with contract law, I want to just take the next 20 minutes to showing you an overview of the syllabus. And if time permits for me now to even go on to share a bit more on one segment or one specific part of contract law, in the hope that at the end of this 20 minutes that you would have learned something useful regarding contract law. So for example, starting with the syllabus, you find that there are 4 main parts of a syllabus. The first part is where we talk about formation of contract, where there will be 4 separate chapters or subtopics within that, where we want to understand and examine what are the requirements to form or to make a contract. So for example, of an immediate question that may come to mind is, must a contract be written? Give it a thought, assuming now that it's a verbal agreement you have with someone over the phone to say, okay, I agree to do the job for you. Is that a contract, right? So verbal agreements binding. What are the requirements for the formation of contract to make it a binding agreement, to make it a binding contract? Beyond just a handshake, right? What would it take in order for it to be formed a binding contract? And so we will spend 1/3 of the syllabus, or a bit lesser of our time, on this area of formation of contract. The second part of our syllabus, and there are 4 parts, will be concerning now this issue or this area of what are the contents of a contract, what are the terms of a contract. So you can see how we are like moving deeper into the syllabus. We started off with examining what would it take to make a contract. Now it's more of what does a contract say? What are the contract terms? Who decides what are the contents of a contract? Now, of course, we know that, and we refer to this T's and C's, right? Terms and conditions. And we sign. And you say, well, once you sign, once you put a tick, you are bound. You are bound, and those are the terms. But is that the case? Have you not experienced this? That, say, for example, in the case of a software update, in the case of where you're going through an online portal and they ask you to read the terms and conditions. Say you want to update, right, your application or software, and they ask you, right, to read the terms and conditions, and then you are given the option to tick either I accept or I don't accept. Do you all, by the way, do you all read all those terms and conditions? I don't think many people do? Why is it that we don't read? Now, sure, you may say, well, David, I don't understand. No point that I read something I don't understand. But no, I don't think that the reason why you don't read is because you don't understand. You don't read for the same reason why I don't read. And the reason why I don't read is because it does not make a difference. I have to click yes, I accept to begin the download to proceed to the next page. You have no choice. In some sense, to put it very bluntly, the vendor, the service provider, they are forcing us to accept the terms and conditions if you want the service. And so I'm thinking to myself now, why bother reading when I have to accept? So I click yes and I move on to download, right? And we don't think too much about it. But if you were to try to read next time, right? You try to read the terms and conditions, you may realize that some of the terms and conditions are pretty onerous. For example, they say things like, we shall not be responsible for any injury that you may suffer whilst using our product. So take an example of a product sale. You buy a hairdryer, you buy a TV or something to the effect like that, and there are some terms and conditions. They came along with the invoice, they came along with the delivery order, and again, we don't read, right, do we? We take delivery of the TV, it's installed properly, the channels work, we sign, that's it. But again, if you were to read, there may be perhaps some disclaimer clause to say we are not responsible for any defect that may arise from this product. Now, so when something goes wrong, and when you do want to pursue legal action, can you? Or are you now bound to the terms of a contract? Now, let's look no further, but a simple case of, say, for instance, our Singapore Universal Studios. A theme park, right? If you had gone to any theme park, and I'm sure that you have seen this, that just before you take that ride, especially the dangerous ones, at the roller coaster ride, what do we see? And we see now a poster, a disclaimer saying, take this ride at your own risk. We shall not be responsible for any injuries that may arise whilst you are taking a ride. You may die, too bad. I know the last part is not there, right? But the point is, they are very clearly putting in a disclaimer clause to saying that we're not responsible. You park your car at a car park, same thing. They say, and the famous line we see in a car park, that poster, right? Park your car here at your own risk. You may go back to the car park, all 4 tires are gone, park your car at your own risk. You go back to the car park, your car has been stolen, park the car there at your own risk. Vandalized, graffiti on the car, on your car, park your car at your own risk. And it seems to be that because of the terms and conditions, you can't sue. Is that really going to be the terms of a contract? And so part of our syllabus will involve a study of and analyzing or understanding of what the law says governing the terms of a contract. What are our rights? Can we object to say that, hey, that's an unfair term and unfair terms are prohibited in contracts? Can we say that? What about then the other balancing, competing argument? That on one hand, as a consumer, as the customer, so to speak, yeah, we want to assert and challenge unfair terms. But what about then the interests of the other party? From a business point of view, they will say, willing buyer, willing seller, freedom to contract. And I need to protect my business interests. I cannot be exposed as a business to infinite, indefinite, indeterminate liability. I need to manage my risks. I need to put in a disclaimer. Yeah, we get that. So how does a law strike a balance between ensuring that customers are protected as that of the interests of businesses? How then do we come up with this position of understanding what can be within the terms of a contract? That's what this part of the syllabus is about, the terms of a contract. The third part of our syllabus will involve this area called enforceability of a contract, as in, how do we know whether would the contract be enforced, especially where when something goes wrong and we want to try to find a loophole out. I think it's true, right? Many of us, that we have signed the contract. The contractual terms are very clear. We have read all the terms of a contract. So right now, it's not dealing with the first part of the syllabus, the contract is formed. It's not the second part of a syllabus, the terms are clear. It's the third part. We don't want the contract to be enforced. We feel as if the manner in which the contract was made might not have been perhaps above board or proper. So take, for example, now this picture that you're seeing here now, which of course, it's not going to be one that allows you a successful legal action, but you get my point, right? That in the course of the making of a contract, it's not infrequent that the vendor or the seller may over-promise and under-deliver. You did not get what you saw. Now, of course, in this picture, it's just an advertisement. I get that. For sure, you go to McDonald's, you order that juicy burger online, you may not get the juicy burger when delivered or when you collect it. And so you may feel cheated perhaps, and you may want to sue. You can't, okay? Please don't say after today's free lecture, you say, well, this law lecturer, David from BAC says I can sue McDonald's because my burger was not so juicy. Please don't say that. I want to be very accurate now. This is an example or an illustration. But the illustration is one that allows me now to escalate the example to now giving you this further instance or situation that are we therefore seeing that advertisements can be misleading? Are we saying that a vendor can say whatever they want to misrepresent and then later say it's just an advertisement? Surely not, right? Especially in the context of online transactions. Now, I get it, that in the context of, say, food, the packaging of food, we may not get what we see. But online transactions, and many of us today now buy things online, and you would check, the description, you read the specifications, the measurements, dimensions, color, you have a picture, you blow it up, you examine from 3D point of view to see, well, this looks good, I want to buy this. Or perhaps now, it could be on Carousel. This could be a second-hand item. And this could be something now, again, you want to make sure that there are no scratches. And they say that, right? In the Carousel post, this advertisement, no scratches, unused, perfect condition. And you see the picture, it looks great. You buy, but it's not unused. There are scratches. What are your remedies? What can you do? Can the contract still remain enforceable, or can we try to now get out of a contract? What are some factors? And there are about 5 factors. Not just the part about misleading advertisements. There are other situations in a syllabus that we'll examine that allows us now to get out of a contract to say this contract was made as a result of a misrepresentation. This was made as a result of a misleading statement and will not be enforceable against me. I don't pay you and I want my money back. I want a refund perhaps. And that's all right as well, right? In the study of contract law. The last part of our syllabus is where we want to talk about performance of a contract and the discharge of a contract. Now, if a contract had been performed, I suppose there's no issue. The issue is when the contract is not performed. When one party is either unable to or is performing the contract as agreed. And right now, because of COVID-19, we are seeing, and I foresee this, in the months ahead, in the years ahead, we will be seeing a lot of possible claims of parties asserting or suing for non-performance of a contract. Now, where if I sue you to say, hey, you are not performing the contract, then the other party being sued may say, oh, that's because of COVID-19. I could not get my supplies from Malaysia. I could not get the staff or the workers to finish the job. Now, he or she, I suppose, in that regard, will have a good reason, but it's my point. The contract is now not performed, and we want to study in this part of the syllabus, what are our rights? What is the consequence? Now, I suppose being COVID-19 and because of all the current circuit breaker rules, it may not amount to a breach or a non-performance of a contract that results in a contractual liability. But what about post-circuit breaker? In a real life situation, is it not true that sometimes parties are unable to perform their contractual obligations due to unforeseen events, due to events outside their control? Now, so when that happens, when due to events that is outside your control, due to some kind of business contingency that occurs and a contract is now not performed. Breach of contract, so to speak, what are your rights? What are your remedies? Right? And that is the fourth and a final part of the syllabus. So in a nutshell, I've now given you in 5 minutes, literally, right, our A to Z of the syllabus for contract law. Okay, and so even in the use of all my examples, you may notice that many of my examples are situations that you can relate to, like signing a contract, like downloading an application and terms and conditions, misleading advertisements, and that is really how your exam questions will be like. Your exam questions are contract situations that we go through, and a study of contract law will allow us now to know what the law says and how to respond to the situation. So contract law is a great subject and extremely practical. Now allow me now in say 3 or 5 more minutes, right, and we'll wind down this session to talk about the first part, talk about formation of contract. And as I said, this is the beginning part of the syllabus. And some of the issues that we want to deal with would be, for example, things like, well, what about an email agreement? As in, that at the process of the email stages, the parties have been corresponding for quite a bit now. I send an email, he replies back, I change something, he responds back, then I say okay, then he says okay. Both parties say okay. Now at that stage, when we agree, is that a binding agreement? At the stage when we agree, has a contract been formed? Right? And so that is something we deal with in real life, and there are real cases. There's something we study also in our syllabus on this particular topic of formation of contract. What about this then? Right? That maybe now we take it one next step, that you then print out that copy of the agreement, and having printed out the copy of the agreement, then you sign, because you have agreed, right? You have agreed, and as required now, you print out, you sign, and you send back. Now, but sending is different from receiving. You may post that hard copy back to that party, but it could be lost in the mail. The dog could eat the particular contract. And so what if the postal or that posted document does not arrive and does not receive? Now, I am sure, depending as to which side you're on, the sender will say, well, I have done all I should, I've sent back. There should be a contract at the time when I send. But the recipient will say, why should there be a contract? I've not received. And so these are just some amongst many other situations that we deal with, and where we study the various laws concerning this issue of formation of contract. Now, I want to give you something practical today, and so that at least you literally have a free lesson, regardless whether you enroll with us for our law courses. Today's session is where we really want to provide you with some value add, that you know something about law, about a Magna Carta, about, say, for example, offenses against the persons, criminal law. And now, formation of contract, and at the very least now you benefit something for staying on with us for so long, right? And so this is now that value add, the content of what it takes in order for a contract to be formed, where there are 4 requirements. The first is easy. There must be an offer made by one party to the other that corresponds with the other party accepting it, in which case it is not wrong to say that now there is an agreement. Offer acceptance does give rise to an agreement. But whilst there may be an agreement, it is not a contract. So whilst every contract is an agreement, not every agreement is a contract. In order for that which you agree, your agreement to be a contract, there are 2 other requirements to be satisfied. And number 3 is that something must have been given in consideration for your agreement. So in consideration for the agreement, I must have given you something. I use an easier word, price. There must be some kind of price given toward that agreement. And also, to be accurate, I've put the word price in a quote. Don't think of price as in just limited to money, cash. Yes, that's something you give towards the agreement. And very often for most contracts where it's money, payable or paid, but it's price. Because this is not just money, but money's worth, something which the law recognizes to be of value. So long as it's something of value, whether money or otherwise, money or money's worth, something of value you've given in consideration toward the agreement, that's it. Now you're one step closer to the formation of contract. And the last requirement is that there must be an intention to create a legal relationship. Not just your casual, frivolous, social, domestic, personal, private kind of agreements that you make with your friend. I agree to buy you bubble tea every day. Now, your friend may agree to buy you bubble tea every day. He does not. Can you sue him? I agree to give you extra coaching lessons to brush up on your tennis, on badminton. Now, a friend agrees to give you coaching, help, or services, but does not do so. If he has agreed, you have turned up, he does not show up. Can you sue him? Now, my last two examples clearly convey the idea that these are social agreements for which it lacks, number 4, it lacks this intention to create a legal relationship. And therefore, with number 4 missing, the requirements for a contract are not made out. There's no contract. But however, if in any situation that you can establish there's an offer made, that there was an acceptance to the offer, that there was a consideration provided for the agreement, and finally now together with an intention to create a legal relationship, that's it, you now have a binding agreement. And a binding agreement is your contract. And that's it, right? We have covered now what it takes for the formation of a contract. And so as we wind out the session, to answer my earlier 2 questions or scenarios concerning whether or not in the case of an email, when it's not signed, and an email that you send to each other, can there be a binding agreement? So you go back now to my earlier slide. I put down that bubble speech box, the text box that says what? Can an agreement arise from emails? Now that you have had 20 minutes of contract law, what would you think is the answer? Yes or no? Maybe just for the fun of it, if you're still watching, you can type in the chat box, tell me now. Would you think that there is an agreement? Put Y or put N. Let's have some participation, okay? Email, can it give rise to a contract? Y or N? Anyone? Before we dismiss you. Yes, thank you, Vincent. Yes, okay. If you answer correctly, correct, then you qualify to do the law program. Answer wrong, you can't join us. Huh? You fail the test. Joking, okay. No, it's just my way of trying to get you to think about these issues. And if you have listened to the past 5 minutes about the requirements for formation of contract, and thank you, Vincent, for your correct answer, because the answer is yes. So long as the requirements for a contract, they are satisfied, it's a contract. In my earlier slide, I mentioned 4 requirements. Did I say anywhere that there was a number 5 requirement that says that a contract must be signed, must be written out, printed out? No, offer, acceptance, consideration, intention. That's it. So thank you, Vincent, for your answer. Right? And of course, the other one was concerning the acceptance that you post. There's this very antiquated rule in England called postal rule. And a postal rule, by label or in name, refers to that literally, postal rule, that upon the posting of an acceptance, it can give rise to an agreement. We don't care whether the other party has received or not. We don't care if the letter was lost. But if I posted, that's it. There is acceptance, and potentially there could be a binding agreement. Now, this is a rule that not many people are aware of. And I suppose it's part of the reason why a study of law is important. We want to know our rights for ourselves personally, for our businesses. We want to be able to safeguard our interests, to manage our legal risks. Contract law is really something which is important, a subject which I truly believe that you will find extremely relevant, right, for yourselves and for your work. And so thank you so much for your time. And on behalf of my colleagues, Mr. Nandi and Mr. Subra, thank you for staying right until the end. We will end our session now. and have a simple 30-second clip of a video, a very short one, 30 seconds for you to watch. And once we finish that short video, we'll end. Right? So one more time, thank you so much for your time watching, wherever you are on Facebook Live or on Zoom. If any questions, please feel free to reach out to us. Right?
The world is changing exponentially. Humanity will see more changes in the next 20 years than it has in the past 300. What we do will change. How we do it, even more so. Be ready. Join the education revolution designed to impact and transform lives. Access 300 world-class programs in over 40 areas of study from over 30 international partners and affiliates in an education ecosystem like no other. Become a future-proof global graduate now. Own your future.